Hello and welcome back to the Canadian Money Roadmap Podcast. I'm your host, Evan Neufeld. Today, we are speaking with Lauren Scharfstein, a lawyer here from Saskatoon, and we're going to be discussing the things on the legal side that you need to consider when it comes to your finances. Lauren, thanks so much for joining me today.
Thanks, Evan. Really happy to be here. Thanks for having me.
Before we get going on the podcast today, just like myself as a financial planner and investment advisor, what you're hearing today is not financial advice because we don't know you and your situation. And so Lauren, as a lawyer, is not providing legal advice. This is just legal information and education. Lauren, is that a decent way to start off here?
Absolutely. That is bang on. We're giving legal information to help you have the tools and the information you need to go get the legal advice that fits to your circumstances. Absolutely.
Perfect. Okay, so looking on your website and knowing a little bit about you and whatnot, you describe yourself as an estate lawyer. What is an estate and what does that have to do with people's money?
Good question to start out with. First of all, an estate is not a scary word. It's a great word. Yeah. An estate and estate planning are very important concepts, particularly in the legal world, but it should be for everybody. An estate generally at a high level is what you have, what you own, what's yours. It can be as detailed as your investments. It can be your RSPs, your TFSAs, but it can also be your car, your clothes, your jewelry, your water bottles, your everything that's yours in personal property, investments, real property, whether that's a house, a cabin property, a vacation property in the US, that makes up what's called your estate. And that matters during your lifetime, and it also very much matters after you pass. And how you manage that both during your lifetime and after you pass is a key consideration that I think a lot of people sort of brush over, thinking, A, it's not fun to talk about, or B, I don't need to handle it yet. And that's a misconception I'm hoping to sort of set aside today. Nice.
Well, yeah, when you think about money, oftentimes people think about someone like myself who's a financial planner or an investment manager, an accountant for a lot of people, but dealing with the legal side of things is really important too. So when you mention an estate, that's largely comes to fruition, I guess, when someone passes. But what are some of those things that we can do in advance on the legal side to prepare one's finances? I assume a will would be a good place to start.
100%. Well, yeah, first of all, lawyers aren't as scary as some people think.
You're pretty scary, though. Yeah.
I don't know who's out there spreading rumors that lawyers are scary and that we're kind of the last people you want to deal with. Honestly, lawyers generally work with you to help ensure that everything's in order to protect both you and your loved ones in the event something happens. So a will is probably the key player of estate planning that most people think about. Most people have heard about a will, seen one, know someone who's passed and helped administer a will. But in addition to that, there's also things that matter from a planning perspective during your lifetime. So at a high level, a will only matters or only comes into fruition when you pass. The will itself you make during your lifetime, and it essentially dictates where your stuff goes when you pass. In comparison, two documents that matter very much for your lifetime are a power of attorney and a healthcare directive. And we can go into a little bit more detail about all those documents, but you need to plan both for your lifetime, what happens with your assets, as well as what happens after you pass with your assets. And getting a lawyer involved to help you do what we call estate planning, and not necessarily just doing a will or just doing X. We work along with your accountants, with your financial planners to ensure the best plan is in place to both affect your wishes as well as keep things easy and as streamlined for your family members as possible.
I found that when we did our will, speaking with a lawyer was really valuable for us because there's a lot of things that we wouldn't have ever considered. I'm trying to think of a good example.
I was say, what are your examples of that?
Well, okay, we name the kids as beneficiaries of all of our stuff. Perfect. I got 2 girls and they're under the age of 3.
Exactly.
What does that mean now for
them? And
exactly. So then at the time we also had a dog. It's like, who gets the dog?
Totally.
And is that a blessing or a curse to get someone's pet?
Yes.
And because the girls are minors, and we didn't have
Guardians,
our
or-
second child at the time. How do we word the language in such a way that it accounts for children that we don't currently have?
Totally.
So anyways, those were some of the things maybe off the top of my head. I'm sure there's many others.
Oh, really good examples.
Yeah.
Yeah. Life is hard, and there's a lot of things for people to just think about and manage on their own. The nice thing about when you seek out a kind of an expert or somebody who practices in that area, they can help discuss your assets, your life, your circumstances with you. And our job is to advise and give you some things to think about on how best to plan for that, or how best to take those circumstances into consideration. At the end of the day, the decision always rests with you. It's your life, it's your stuff, it's your family. But I don't expect people to think all those things through from start to finish. I rely on my accountant so heavily. I understand tax. I can do it from a legal perspective, but I don't want to file my tax returns, and I still call them and rely on them as the expertise. Same with a financial planner. So we all have our own kind of area of expertise, our own silo, and we can oftentimes shed light on something you hadn't considered.
Right. Awesome. So maybe we're kind of skirting around the big question of here, but like, who actually needs a will?
Everyone.
Everyone.
Every single person over the age of 18.
Anyone within the sound of this podcast needs a will.
Yeah. So
Okay.
yeah, if you're under 18, you can't. You're not deemed to be an adult yet to be able to. You probably can't really even own anything. Kind of like your girls, who, if they're named as beneficiaries, it's a bit of a run around for them because they're not 18. But anyone over the age of 18 should have a will. It can be simple. It can be detailed. It can be everything in between. But a will is simple as saying who would be your executor, who is the person who administers your estate, who's the one that collects all your stuff, who's the one that closes your bank accounts, who's the one that deletes your Facebook, who is the one that kind of does all that heavy lifting, and then who gets your stuff, who are your beneficiaries. Those are the key hallmarks that everyone should have in a will. And it can be as simple as that, or it can be as detailed as dividing up a company, or doing more detailed tax planning, or dealing with a second marriage and split families. Those are the ones that are exciting. No, they're all important, and everyone needs one.
So in a really simple case, say someone is single, they've got a TFSA, maybe a pension plan at work, they're renting. What's the case for that person needing a will? What's a circumstance for how that could potentially go wrong without a will, maybe?
Well, let's call this person Helen, because I like names. So this is Helen, and Helen's got her TFSA, her pension at work, and she's renting, so she doesn't own any real property. No spouse. I'm guessing maybe no kids for Helen at this point. If Helen passes, everyone's left in limbo. And my guess is Helen's got parents. Helen's probably got siblings. Helen might have a common law spouse. Helen might have a partner. And everyone is basically left wondering, okay, now what do we do? Helen passed, and now there's nobody named to be her executor. There's nobody named to administer her estate. There's nobody to terminate her rental agreement. There's nobody to contact the pension services and see if there's a named beneficiary. There's nobody to contact the financial advisor and say, hey, she's passed. Was there a named beneficiary on this one as well? And if there's not, it falls to what's called her estate. And if there's nobody designated on who gets her estate, it's basically left in limbo until we make certain applications to the court.
Who makes that application to the court?
Well, lawyers can help make the application, but really it's the individual. Lawyers can kind of help do the paperwork, and generally speaking, depending on the size of the estate, it could be something that can be done on its own. There's a list in the legislation sort of by priority of individual who should be applying or who can apply. Spouse, adult children, parents, siblings, aunts and uncles, kind of going down the list of who is closely related to that individual that passed without a will, that should be kind of stepping in and helping administer. So that person makes the application to be the administrator, kind of the pseudo executor. That's the word we use if there's no will. They're the administrator, but they're not necessarily the one who gets the stuff. They apply to be the one to have the authority to speak on behalf of Helen's estate. They're the ones that can make the contact. My guess is Helen probably has a bank account. It's probably sitting at TD and just sitting there, and they've maybe closed it. And now who gets that money? Helen probably has property. She's probably got clothes. She's probably got jewelry. She's probably got, like I said, water bottles and coffee mugs. Who can donate that? Who can deal with that? Who can give that to Helen's mom? Who has the authority to kind of handle that? And then the big question is for Helen, who gets the stuff? And a weird common misconception that's out there too is that it just goes to the government. I hear that
Right.
a lot.
Yes.
If you die without a will, that it goes to the government. That's not the case. Also in the legislation, there's a list based off sort of your next of kin or the people that are close to you in your family. And depending on who survives you, depending on your relationships, they sort of get a spouse, kids, parents, siblings, that sort of thing. But who has to determine that? Who has to find those people? Does Helen have a spouse? Have they lived together continuously for 2 years? They might not be married, but are they common law? That changes things. So we get into this mess, maybe is a really negative term, but at least in my practice, I find the ones that don't have the plan, don't have the will, don't have things set up are the ones where the fights happen the most, because there's no clear distinction, no objective paperwork to look at and follow. It then becomes a bit more of a free-for-all and definitely a bit more time consuming and more expensive to make those applications and try and get things distributed and administered.
Right. Yeah, I've heard some people say that if you have a spouse that you love or kids that you love or parents that you love, do the will, because you're going to leave potential big problems.
100%.
Even if you don't. So I was setting you up for an easy one, but it's just like, oh my goodness, there's a lot of other things to consider there that are much more complicated when it's all said and done, right?
Absolutely.
Yeah. Okay. So that's good. So everybody needs a will, even if you have a very simple situation. Mm-hmm. That's great. How do I get a will?
Really good question as well. So everyone, I'll go back. Everyone needs a will. And I often hear from people that it's, well, I don't really own anything, so I don't need a will, or I don't have a house yet. And trust me, houses are, real property is something that you really want to make sure you have a will and everything's done correctly when you have real property. But everyone says, oh, I don't have a house yet, or I don't have kids. And kids, again, are a big one. You want to make sure you're naming a guardian or someone to look over your children, because in the event something happens to you and your spouse, we've got to make more court applications to get you named as guardian, whoever the loved one is that looks after them. So those are
there's no default there, right?
There's no default.
Like applying to the courts, this sounds like work and time, right?
And money.
And expense, yeah.
People always say, well, I don't want to pay for a will yet because I just don't have a lot of stuff. And I said, you don't know you get in your car every day and you drive to work. You don't know what's going to happen. And the cost on the back end and the cost comes from your estate. But if there's not enough there, it comes from your family members. You pay way more on the back end if your planning isn't done well on the front end. And it's time. And when someone passes, you should be focusing on the emotional aspect. You should be focusing on dealing with personally and with your family with that passing, not with making court applications and dealing with lawyers. Yeah. So the planning on the front end is so important. So yes, kids, assets, house, that sort of thing are key hallmarks where you think you should get a will. But even if you don't have those big things, it's still super important. And so that I always want to kind of hit those misconceptions out of people's minds right off the get-go. And then how do you get a will?
Yeah.
Okay. So generally speaking, in my practice, I think it is tighter and safer to have one duly executed with a lawyer. And the reason...
What does duly executed mean?
That the requirements at law are met in terms of signing with a lawyer.
Perfect. I'm putting Lauren on the spot here with a bunch of these questions and detailing things here. So this is good. Nice work.
So it's in the legislation, what makes a valid will, there's both a way to do it streamlined there's a way to do it with a lawyer. That means one lawyer, you have to have two witnesses and one of them is a lawyer. There's another way of doing it of two witnesses that are not lawyers. And there's additional paperwork that has to be done by those non-lawyer witnesses. And then the third option is fully in your own handwriting, signed and dated by you, not typed, in your own handwriting, but no witnesses needed. That's called a holograph will. So you can go down any of those avenues and have a will. And at the outset, if you're listening to me and you're saying, Lauren, you're just trying to shamelessly plug lawyers and get yourself work and all that sort of stuff, that's so not the case. And I would care way more that you have something written on a napkin and you've signed it and it at least says who your executor is and who gets your stuff. That way, someone has something to go off of. We have something to follow in the event something happens. Going back to my first comment, though, from my experience, and again, because lawyers often get involved when things go poorly, I see those handwritten wills or those non-lawyer witness wills often get challenged more. People come up and say, well, he didn't have capacity when he did that, or these people weren't actually witnesses, or I see them where they did it with their neighbors and someone didn't sign one spot, or they put someone's name wrong, or I've actually had it where the testator, the individual themselves, they didn't sign. The two witnesses signed, but they didn't. And it just, what that does is create extra hurdles to try and get that document perfected, that will perfected and deemed to be valid. So if you have the capacity and you have sort of the backing to see a lawyer, meet with a lawyer, and again, I know there's a cost associated with that for sure, but on the front end, you pay that cost and it saves you on the back end. Getting it done with the lawyer, making sure it's done right. And a key thing that lawyers do is, in order for us to do estate planning or do a will or any document, a power of attorney, healthcare directive, we have to determine that the testator has capacity to understand the nature of the document, that they understand the impacts of the document, and that there was also no undue influence, so that they weren't being told what to put in their will or to put in their document. And those two key things that a lawyer reviews is really, really important to ensure that that will is worth the paper it's written on. Because if you do a holograph will or you do it with two lay witnesses, no one's taking notes about either of those things. No one's doing that analysis. And after you pass, if somebody wants to make a court challenge or any challenge to the validity of either of those documents, those are the two avenues which they do it. They'd say you didn't have capacity or you were being unduly influenced. And when you meet with a lawyer and a lawyer takes notes about those two things, that pretty much is not necessarily a slam dunk, but a really, really key piece to ensuring that your will is defended and what you wanted is seen through. Whereas if you do the other two avenues, there's not that evidence. It becomes a he said, she said. It becomes no, I know mom was already starting to fail by that point. I spent a lot of time with her. No, mom was great. Mom was totally, she knew exactly what she wanted. And no, you were there. You told her to write this. That costs money. That takes time. If you can get it done right, get it done right.
So I'm a millennial and we love doing things online. There's a lot of places to do things online that I'm sure are probably as good as an online thing could be, but you're describing a lot of scenarios where, the challenge could still be put in place, right? And it's tough to prove someone wasn't under duress or whatever the case may be when the will is done online. So those common challenges, even if you're doing an online will correctly, those common challenges are still in place because you don't have a lawyer as a witness. Would that be fair to say?
Totally fair. And those online ones are scary for a couple reasons, but then I'll come to some good news at the end. The fill in the blank wills online oftentimes are set up so you as the testator are the sole signatory. So you either print it off or you fill it in, or generally print it off and you handwrite it. That then qualifies as that holograph will. But any of the wording that was not in your handwriting, so any of the blanks you didn't fill in, falls away because it wasn't in your own handwriting. Therefore, it doesn't qualify as a holograph will. So we're left as lawyers, and I've seen this in litigation, trying to figure, we take away all the typing and we have to read your will only with your handwritten fill in the blanks and your signature at the end and figure out what you meant as a testator and what you wanted to happen.
Oh my goodness.
That is just setting everyone up to fight 110%. Then doing things online. I'd like to type. My handwriting is awful. I like to type, but that's not a holograph will. You typed it up, and if you do an electronic signature or even if you print and sign it, again, not in your own handwriting, therefore you don't qualify for a holograph will.
Oh, okay.
So you could type one up and have a printed out and you sign it with your two witnesses. But again, that has to be properly done. And the one file I'm thinking about particularly, that was exactly what the testator did. He typed one up, his neighbors came over, they signed it. He just forgot to sign. He initialed the bottom of every page, but forgot to sign on his signature line. And then in order to administer an estate with the court after you pass, certain documentation needs to be submitted, which includes an affidavit of execution. So Saskatchewan is one of the provinces that requires this extra document, which basically says I met with blank and I was there with this other witness, you name the other witness, and I watched them sign. And you swear that in front of a lawyer or a notary, and that's sort of the confirmation that the requirements of the Wills Act are met. As lawyers, we get that done immediately when we sign. That way it's there with the will when someone passes. I don't expect individuals that are not lawyers to know that requirement. And oftentimes that's missed. So they sign the will with their neighbors, they put it away, and then mom or dad passes and kids find it. And they say, well, now we need to probate, or now we need to administer with the court. And we're left trying to find these witnesses to do this affidavit of execution. And sometimes their names aren't even there. It's just a signature. We have no idea who it is, and we're left running around. And it's just, again, more time, more stress, more money to try and fix those things. Also, there's a requirement if you sign with two individuals that are not lawyers to fill out a document that says non-lawyer witness, and those sort of requirements there. And it's just more likely that those get missed with the sort of electronic or typed up wills, even if you're semi-meeting the requirements. But I'll get to the good news. So we now have a bill that's gone through second reading and is
here in Saskatchewan.
Here in Saskatchewan, you
Okay.
bet. And it's at the committee stage. And it will allow for electronic wills. And COVID was a really, really great impetus to us moving towards more electronic stuff. Now we can finally witness signing of wills, powers of attorney, and healthcare directive through electronic means. So if you like doing things online, you don't want to come down to a lawyer's office, that's okay. You can meet via Zoom and you can get things signed up. The will still had some requirements for what we call a wet signature. So I would send the documents in the mail to you. Once you get them, we hop on a Zoom, we review, we sign, and then you put them in the mail, send them back to me. And I then meet with you on Zoom again, review the will with you, and I sign. So we have one kind of official, formal paper document that fits with the old requirements that your will is a hard copy, and we have one original.
Are most provinces that way? Can you speak to that?
For the wet signature requirement?
Or like any of these changes that are...
For the electronic changing, we are actually, BC is the only other place that I know of that is moving towards electronic wills.
Okay.
I think they were the first people to put it in, first province to put it in place, and I believe we are the second.
Okay.
So it's pretty new. But what this will allow is for us to actually meet online, on Zoom or anything, or even in person, but I imagine it being more so that we're in different places. Or for example, you're in the hospital and you're maybe under quarantine, or it's just you're ill and you don't need people to come with their germs. We could meet via Zoom, via FaceTime, and we could actually do an electronic signature now. I don't need to send you the documents in the mail. It's not a hard copy anymore that you sign and I watch you sign and then I sign. You could DocuSign, which again, depending on how the legislation comes out, I'm not totally sure if DocuSign particularly will be allowed, but the idea is that sort of paint your signature on it. And then I do it at the same time with my electronic signature. And then that PDF or that electronic document then becomes your will.
Okay.
This is game changing. And
Yeah.
it's also very, very scary for lawyers who have practiced with the understanding of the hard copy will.
Right.
Where is it stored? How do we know it's not edited? Who has the original? Is there an original?
Right.
But needless to say, it's an exciting kind of progression in the law to allow for these millennials who like to do more things online and don't necessarily want to come downtown and park and see a lawyer, or they just do all their meetings remotely and they sign most things by DocuSign. I sign most things with my financial by DocuSign, and it's lovely. Yeah. So we're moving towards that, at least in Saskatchewan and BC, to allow for a little bit of that generational change. And I think that's a really, really exciting development in the practice of law.
Cool. So I'll take this moment to remind people that law is practiced by province. And or the language of which you could probably clarify here a little bit, but anyone who's listening outside of Saskatchewan, make sure you're speaking to a lawyer in your province to advise specifically on issues that are relevant to you and where you live. Would that be fair to say?
You bet. There's certain things that are national or cross-country criminal law, some bankruptcy stuff that we've got legislation that is federal. But for wills and estates and things like that, absolutely, it's a provincial. So we've got our Saskatchewan legislation, Alberta's got theirs, and certain provinces mimic each other a little bit more. But that's definitely from a wills and estates perspective. I'm licensed to practice in Saskatchewan. That's the legislation I know. And yes, you'll want to kind of review that with a lawyer in your particular province.
Perfect. Great. So it sounds like you gave a few examples there of things that have gone wrong potentially, or like ways that you could set things up that you would want to avoid. Maybe, do you have a good example of like maybe a complicated situation that went really well so that you can see.
100%.
Maybe those are more common than not for people that would deal with a lawyer already, I guess.
Yes. So those are the best ones.
Yeah.
When we've done the planning on the front end and then we see it play out and it goes well. So that's why I enjoy estate planning so much, less estate litigation, because I don't like the fight on the back end.
Right.
I like to see it go well on the front end. So great examples of that are particularly here in Saskatchewan, we've got a lot of farming individuals and people who own a significant amount of farmland and a significant amount of farm equipment and have a significant net worth. They've done very well for themselves. Oftentimes it's passed down from generation to generation. It's the family farm. Proper planning for family farming operations is critical. I cannot stress that enough. The mess that can come from no planning or improper planning for family farming operations is just, the magnitude is significant. We've seen it where it's gone so well and it's wonderful. So in particular, it can start from as early as putting a power of attorney in place. So mom or dad is managing the farm and dad starts to decline a little bit and he's named mom as power of attorney. Mom can continue to still access the farming bank accounts, whether she's joint or not. She can continue to sign the rental agreements on all the farmland, even if she's not necessarily joint on it. She can continue to run the farming operation as attorney for dad. Then as they get a little bit older, we can figure out transition of the farm. What is that going to look like? Is there one child that farms and two that are in the city that have no interest in farming? How are we going to get the farmland to the one child who needs it to operate the farm, but keep things fair? And I'll say fair isn't necessarily equal and equal isn't necessarily fair, but how can we plan with other assets to ensure that the kids are treated fairly with the family farm and sort of the transition of that? So we sit down, we can have that proper planning and we can set things up that they can somewhat easily transition to the next generation. Particularly, it's easier for sure during spouse to spouse, but then to the next generation of child. And we can do it on a tax deferred basis. And that is the Income Tax Act. That is a federal piece of legislation. Here in Saskatchewan, we've got lots of farmers, so it applies to us, but it also fishing operations, which is less common here.
Yeah, we don't have a lot of Diefenbaker trout operations here on a large scale.
But I'd love to see one
Sure,
day. That'd
why
be
not?
amazing.
Yeah.
But we can set it up so you are transitioning the family farm to your loved ones in a more streamlined fashion and also ensuring there's those, we're utilizing the really beneficial tax treatment of deferring the sort of capital gains on that family farming operation that may have passed down from grandpa, great-grandfather, all that sort of thing. Not to make this about tax, but tax on death is a very significant thing. And if you don't properly plan for it, you don't have to have significant wealth. It's not just for people with farming operations. And I'm sure you've talked about this before and you know about this RRSPs, for instance. If you've got a large RRSP and you pass and you have a named beneficiary on it, that amount of money goes to your beneficiary. They get the benefit of that cash, that value. But your estate has a tax burden associated with the withdrawal of that RRSP as if you pulled it out during your lifetime.
Yes, we say the tax man cometh, whether you're alive or dead, he's coming.
Yes.
Yeah.
So you can have significant wealth, but if you don't know how best to plan for it to ensure a proper transition or at least a more steadfast transition, you and your loved ones are often left trying to kind of pick up the pieces and figure out if there's enough cash there to cover tax burdens. So I definitely see it with farming operations where it's at a high level. We do really detailed planning and we see it pan out and the farming operation just naturally flows to the next generation. The kids that are not interested in farming get their assets. They feel that they've been treated fairly. Everyone knew the plan. Now everyone sees the plan go out and we basically defer the tax man for another estate.
Yeah. I've heard it say, and maybe I've said it myself here, that upon your passing, your money can go to three places. Go to your kids, the government, or charity.
Yeah.
I know that's oversimplifying it, but you can only pick two.
Yeah.
Yeah.
Well, no, you can pick all three.
Yeah, well, yeah,
we can pick all three.
The government will get their fingers in there anyways.
Yes,
but
yes.
broadly speaking, if you plan accordingly,
Yes.
you can kind of do that thing. So as far as charitable giving goes, We've done a few episodes on some opportunities there, but how do we, like, say, for example, I wanted to be charitable upon my death and the kids don't need every penny. What are some options or things that you've seen where people have been able to be generous with their wealth after they've passed?
Love that question. This is one of the coolest planning that I've seen my clients do, or we've been able to do for my clients. And I remember when I first started practicing estate planning, I had some clients with significant wealth saying, I don't want to give all my wealth to my children. I will give them some, but they are going to work hard and they are not going to just get this large inheritance and expect it and wait for it. Philanthropy, being philanthropic is important to this particular family I'm thinking of during their lifetime. And they wanted to teach their kids that. They wanted that to be sort of inherent in the family makeup. And at first I thought, this is crazy. What do you mean you don't want this passing along to your kids? You've built all this. And then the more I've seen it through other clients and I've seen it pan out, it's really, truly exceptional to set things up this way. And to be able, also it's a great tax benefit to your estate. And there's a few different ways you can do it. So you can either say, I give X amount to my kids or to whomever, and then X amount to this charity. And then it's just a clear sort of dictation that this goes to this charity. And I'll put a little asterisk or caveat that if you are doing charity planning, I do recommend working with a lawyer to ensure the wording is correct, because there's a concern that if you are too specific about where you plan or what it has to be used for, that gift can fail for being against public policy or too specific. Also, if you don't use the proper registered name for the charity, you don't get the tax benefit. So there's some key kind of provisions or key things that you want to make sure you're doing. So you can either do it as simple as that. I give this to this charity and they can use it for whatever they want or for this particular bursary or whatever. You could also set it up that you have sort of a private giving foundation. And this one I'm seeing a little bit more in my practice. And particularly, I've seen it that banks are helping these individuals set it up. And it's a private giving foundation that you actually set up during your lifetime, but you can leave your assets or part of your estate to the private giving foundation, and it continues on your behalf after you pass. The third option that I've seen a little bit more is that you actually set up a not-for-profit, sort of a board before you pass again as well. And you are on it and you bring your kids in on it as well. And you meet once a year or however often you want, and you decide which charity to give it to. So this family I was thinking of at the very beginning, that's what they did. We set up a not-for-profit during mom and dad's lifetime, and we left a majority of their estate to that not-for-profit. And we created the bylaws and the sort of agreements in that corporate entity, that nonprofit corporate entity, that after mom and dad's passing, all the kids would get together once a year and decide on a majority basis where those funds would go for that year. And it ensured that sort of a legacy on mom and dad's behalf was continued, that the kids, regardless of where they lived or whether they were close or not, they came together and worked as a group, and they could feel that they were doing something with mom and dad's money and kind of paying it forward with mom and dad's philanthropic approach. And it wasn't so much that just when they passed, everything went to the charity and they never saw it again. It got to be an active thing. So there's some really, really cool planning things we can do with that.
Yeah, that's awesome. From the legal side, it's neat to see the complexity or opportunity that comes along with planning for those kind of things too. Okay, so we could talk all day long here, but when it comes to figuring out your will, power of attorney, all these different things, my suspicion is a good place for people to start would be to get yourself organized first, because a lot of people don't know what they have in the first place. I have a spreadsheet, a little plug for myself in the show notes here. You can find that. It's called Your Full Financial Picture. You can list everything in there, and it becomes really simple so that when you speak to somebody, you actually know what you're talking about. But anyways, beyond just getting yourself organized, what's a good place to start when you're looking at the legal side of your finances?
I love that, Evan. I like the idea of a spreadsheet. Anyone who can kind of...
It's simple, it's painless, yes, I promise.
And jot down a few things. Get yourself thinking about what you have. The one thing I will say, though, is don't let that deter you. So I often have clients who say, well, what do I need to... how much planning do I need to do in advance? And some people give out this huge questionnaire or form that it does get you thinking, but I never want my clients to feel overwhelmed by that, because I've seen it act to their detriment by saying, well, I don't have the time to fill that out, therefore I won't get it done. You can come with no idea, and you can sit down with me, and my job is to pull out that information from you. And I have had clients who have maybe just forgotten about a bank account or something like that. That's okay. You let me know, we can figure that one out. But I should be able to ask you the right questions for you to give me the information I need. And there's nothing wrong with saying, I'll have to look into that. So for instance, name beneficiaries on a TFSA, an RRSP, or a life insurance policy. Particularly, let's take a work life insurance policy. You probably filled that out when you started your job 20, 30, 40 years ago. You probably forget who you have named as your beneficiary on that. And so if you are prepared for the first meeting or whatever conversation we have and you know all those things, great. But just because you don't know that doesn't mean you're not ready for estate planning.
Perfect. This is better than I was setting you up for, that I thought I was setting you up for. This is wonderful.
Yeah, that you can be as detailed. And I take my dad as my example all the time. That guy's got a whole book of everything and right down to every bank account phone number with the last statement of the amount on it.
Wow.
You can be that diligent, but you do not have to be.
Yeah.
We can sit down, we can have a conversation. I get to know who you are. I get to know your assets. I let you know the things that you need to look into afterwards. And I often say to my clients after the first meeting, I said, if I don't leave you with any homework or I haven't left you with any things to ponder or think about, I haven't done my job right. So don't think you need to know everything coming in. It's very much an ongoing process. And on that, it's also, once we do your estate planning, once we do your will, once we do your power of attorney, your healthcare directive, it's not set in stone. That changes. Your assets change. You get more investments. Your investments increase. They decrease. You get an inheritance. A new grandchild's born. Your life changes. And we change your estate planning documents along with you as your life changes.
So what are some periods of time or life events that would warrant a review of your estate plan?
Absolutely. I say any kind of big major life change in your family or your finances. So again, if you win the lottery, that may be changed.
That's
maybe
pretty big.
Yeah, it's pretty big. You may change some things. Also, if you've lost some wealth, or maybe if you've given a significant chunk of your wealth away during your lifetime, which I always recommend my older clients to do too. Live your life, give your money away, enjoy it, spend it. But lots of clients will plan to maybe give a certain dollar amount or a percentage to certain individuals. And as your estate increases or decreases, you'll want to review those numbers or those percentages to make sure it still fits with what you want. Also, any changes in family. So death's the big one. So if your spouse passes away, chances are you've left everything to that spouse. They're probably your executor, your attorney, your healthcare proxy. So we really want to review that and ensure we've got proper planning there. And births. Grandkids come into the picture, and there's ways we can plan for it that you might not know the names of everybody, or if they're going to have more, that's okay. We can plan for that sort of future contingency. Beyond any sort of major life change, I say about every 5 years. Pull out your estate planning documents, brush them off, just make sure it still fits with what you want or what your plan is. And if it does, perfect, put it away for another 5 years. If it doesn't, say, what do I need to change here? What has changed in my life that I need to sort of work around? And changes aren't that extensive, or it's not going to be this huge legal cost that you should be fearful of, particularly if you're going back to the same lawyer. They already know you. They already know you. They know your assets. That change isn't going to be kind of a huge deal to them. So see it as an ongoing moving document with you.
But also keep in mind that the changes that you make to it has to go through the right channels. So hopefully this isn't a spoiler alert this isn't a pop culture podcast here, but I'm watching Succession on HBO.
I haven't seen it, but I heard it's fabulous.
Yeah, okay. It's tough to recommend from a content standpoint. Like broadly, it's classic HBO and whatnot. But the concepts are very interesting and relevant to this, because on a recent episode there was not an entire will, but they just keep referring to it as a piece of paper was found with hopes and dreams and wishes all typed up, signed, and then there have been pencil marks added, and it appears that either one part was either underlined, but it also looks like it was crossed out.
Yes.
And this is just kind of it's a dark comedy, right? So it goes back and forth trying to figure out what was actually meant by this.
Totally. But that is not Hollywood. That happens.
Yes.
That happens. I've seen that happen. And people often have a copy of their will, sometimes their original will, and they cross it out and they write something else. And they think, well, that's good enough. Honestly, it's better than maybe nothing. But what that does is open the door for people to question it or say, who made that change? Did they make it when they had capacity? Did they make it when they didn't? Did they have someone there telling them to do it? Is that even their own handwriting?
I think these are all the questions they answer on the show. I feel like an estate lawyer was in the writing room for this episode. Yeah.
And so again, I had some clients during COVID when we were on official lockdown, and it was before we were able to do anything remotely, who really, really wanted to make changes to their will. And there is an ability for you to cross it out and put it and initial it. I always recommend putting a date beside anything you do ever if it's in your own handwriting, so somebody has a time frame to look back to. And if that's your only option, go for it. But again, to save your family the heartache of everyone fighting and the cost on the back end, we can just do it right. We can just get a whole new will done, or we can make that change appropriately. Some people do codicils, which is sort of like a one-pager that makes the change instead of executing a new will. My practice is not to do that, because I've seen that not play out well in terms of either the codicil isn't worded appropriately, or again, there's a concern about when it was done or what particularly it revoked. Again, it just opens up more avenues for debate and discussion. And as an estate planner, we try to avoid estate litigation in all aspects because it's messy.
Gotcha. I don't want to leave on just that note there, but is there, you describe estate planning as the, what is it, the happy side?
The happy areas of law.
Yeah, so maybe just end on that, on some final thoughts to wrap things up of why this can be a great thing for people to do. And I'll let you have the last word here, Lauren.
Amazing. Well, I love ending on a happy note for sure. Yes, estate planning, I say I'm lucky I get to practice in the happy areas of law. And I see estate planning as a happy area. And people always say, what do you mean you're talking about death, or you're talking about kind of sickness if it's a healthcare proxy, or you're talking about being incapacitated if it's power of attorney? These are some very depressing things. And I think absolutely not. What you're doing is you're being proactive. Before all these things happen, you are sitting down and saying, whoa, if this was to happen, who do I trust? Who do I want to have my stuff? How do I make it easy for them to get it? How do I ensure my wealth transfers in its most full sense, that I'm not paying, that the tax man isn't coming and taking all of it? How do I sit down and feel empowered to decide for myself where my stuff goes, the stuff I worked hard for and the stuff that I want to see go certain places? And I do see it as a very, very empowering process. And as people learn things about what they can do and all that, I see those lights go off in their head, and they feel so relieved once those documents are in place, or once a plan is in place. And it truly, in my mind, is a very, very happy area, because it gives you comfort and you feel accomplished. And I just love being a part of that with my clients.
Awesome. Thanks so much, Lauren. This was really helpful for me, and hopefully for you as the listeners. If someone wants to get a hold of you, what's the best way to find you?
The law firm's name is Scharfstein LLP. We're here in Saskatoon. You can we've got a website, Scharfstein LLP, phone number 306-653-2838, or all the millennials out there, emails probably what everyone likes to do. And that's lsharfstein@scharfsteinlaw.com. I'm sorry you have to spell that twice.
No, that's okay. I'll put it in the show notes so people can just click on it. Yeah.
Amazing.
Awesome. Thanks again, Lauren.
Thanks, Evan. Happy to be here.
Thanks for listening to this episode of the Canadian Money Roadmap Podcast. Any rates of return or investments discussed are historical or hypothetical and are intended to be used for educational purposes only. You should always consult with your financial, legal, and tax advisors before making changes to your financial plan. Evan Neufeld is a certified financial planner and registered investment fund advisor. Mutual funds and ETFs are provided by Sterling Mutuals, Inc.